Assalamualaikum warahmatullahi wabarakatuh to Dr. Muhammad Samsudin. Today, our group will present about 4 provisions on female employees in Malaysia as stipulated in the Employment Act 1955. Our group members consist of 5 members, which is first, Nurin binti Mohd Saberi, second, Afiqah binti Zamri, third, Nurin Shafinaz binti Mahmud, fourth, Alia binti Sobri, and lastly, Aidura Balkis binti Yosri.
Assalamualaikum sir, my name is Nurin Shafinaz and our group will present about the 4 provisions on female employees in Malaysia as stipulated in the Employment Act 1955. Employment Act 1955 is the fundamental employment legislation in this country prescribing the statutory minimum standards of terms and conditions of employment. The Act enshrines the rights of both the employees and employers and the obligations or responsibilities they are obligated to fulfill to have the legal protection. The scope of Employment Act 1955 only covers workers who are defined as employees under the Act. In Malaysia, the Employment Act 1955 is the law that oversees the employment matters in the private sectors. The Employment Act applies to Peninsular Malaysia and the Federal Territory of Labuan, while Sabah and Sarawak have their own labour ordinance respectively. Moreover, the Act enshrines the right of both the employees and employers and provides many forms of protection, especially for female workers. Various statutory provisions relate to women protection at the workplace. In Malaysia's employment field, women contribute as an important workforce in development of our nations. Therefore, the Employment Act 1955 provided various protection for them. The contents of our assignment highlights an extension to women's rights as an employee as provided in the Employment Act 1955. Our group will determine the statutory entitlements available to women workers under the Employment Act, and its regulations provide adequate level of protection to women workers. Hence, the criteria for determining the scope of women workers covered by the Employment Act 1955 are discussed by other members group.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aidura Binti Yosri and I will present about prohibition on night work under Section 34 in Employment Act 1955. Okay, this prohibition will protect the rights of working women in Malaysia from working at night. Employers are not allowed to require their women workers to work between 10 p.m. to 5 a.m. This prohibition only applies to industrial or agriculture undertaking. Women still can work at night in sectors such as commerce, hospitality, public health, and entertainment. And lastly, employers may apply to the Director General of Labour for an exemption from this restriction. That's all from me.
Assalamualaikum warahmatullahi wabarakatuh. My name is Afiqah Binti Zamri. Now I will present about prohibitions of underground work in Article Employment Act 1955, Sections 33. Employment regulations. Despite the fact that the Malaysian Employment Act 1955 was received by the Employment Amendments Act 2012, some portions of Act are still considered discriminations on the basis of gender. Perhaps it is necessary to mention the sorts of discriminations while discuss the aspect of discriminations under the Act. Discriminations can be jure, which means it is legal, or de facto, which means it is occur in actually or practice. To detect the sex discriminations, it is necessary to examine not just the aim of purpose expressed in regulations or actions, but also the actual consequence produced. In Section 35 of the same Act also obligates women workers not to be employed by any underground work. This provision may seem noble, it is intended to protect women, but the fact it is a form of preventive discriminations against women as those who need to be protected because they are weak. Thank you.
Assalamualaikum, my name is Alia Binti Sobri and I will explain about prohibition of employment by the minister. Employment law provides special protection for female employees. The law does not require equal pay for equal work and does not prohibit discriminations against women. The provisions of the Women's Act are primarily concerned with working hours, the minister's prohibition on the employment of women, and maternity allowance. Here it explains the ban of the minister's employment in accordance with Article 36 of the Employment Act of 1955. Notwithstanding the provision of this part, the minister ban on employment means that the minister prohibit the employment of female workers by ordinance under the circumstances or conditions as described in this order, or it means to allow. This section is a continuance of section 34 and 35, which represent no night work and no underground work. Based on the previous section of section 34 and 35, the government reserved the right to ban female workers because women are special creatures. They cannot do certain things and must be protected at any cost. According to Article 34, employees are at risk of sexual harassment and rape and will not be able to work after 10 p.m. We also know that this curfew does not work for men, as some jobs such as taxi drivers and bus drivers have to work from morning till night or until dawn. Some may think that government is doing this for sexism because women want to be treated the same as men. However, we already know many cases so women are not easily endangered. There were 315 rape cases in 2009, but it will increase to 304 in 2020. This shows that it will have a positive effect after the government enforces it. As you can see in section 35 of the government has enforced a ban on underground labor. This means that female employees are not allowed to work underground. In the current economic situation in Malaysia, where mining of underground minerals is extremely rare, such restrictions are meaningless. When the government does this, some believe that the government does not believe in women's abilities. But because they are mostly men, they protect them from being hurt when something bad happens at work. It's supposed to be, however, as the mining industry has traditionally been a male-dominated sector, there were some challenges in hiring women in the industry. That's all from me.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurin Binti Mohd Saberi. I will present the last provision on female employees in Malaysia as stipulated in the Employment Act 1955, which is maternity protection. Under the provision of maternity protection, every female employee is entitled to maternity leave for a period not less than 60 consecutive days, and also entitled to receive from the employer a maternity allowance. However, they will not be entitled to receive maternity allowance if at the time of the confinement she has 5 or more surviving children. Next, when a female employee is entitled to maternity leave, she shall not commence earlier than a period of 30 days from the date of confinement, and if she is unable to perform her duties satisfactorily, an employer, however, may ask the female employee to take such leave 14 days earlier. A female employee eligible for maternity allowance is entitled to receive from the employer for each day of the eligible period a maternity allowance at her ordinary rate of pay for 1 day. That's all for me. Thank you.
It is concluded that, based on the aforementioned discussion, the Employment Act includes 4 types of provision on female employees in Malaysia. The Employment Act 1955 indicates a relatively serious attention is given to protect the female employees' rights. It is concluded that the serious effort of particularly Malaysian government protecting the rights of the woman employee can be seen from various changes and transformation that has been introduced to the employment laws. Generally, it is able to identify the regulation related to female workers' exploitation in the Malaysian employment context. Reasonable protection schemes for female workers are important factors to promote economic development and to protect women's health. The employers have no right to force their employees to do something that beyond the Employment Act, such as working on the night shifts and doing the underground work. The safety of the employees is the major priority, and also it has been mentioned in every section in the Act.